May I please, your lordship?
Yes.
I beg to mention one unlisted bail matter. It's an anticipatory bail for today.
Today not possible, tomorrow.
May I please, Lordship? Lordship, I beg to mention item 6 and 7. Lordship, here in item number 6, also I have instruction to represent the respondent, but yeah, I have to file my wakalat number. So I maybe I lost some more time.
Respondent.
Respondent.
Anybody for petitioner?
Sir, I have already informed. 6 and 7 both are connected. In 7, I have already filed.
Then a place for the petitioner. Nobody petitions, no?
I informed them. This matter may be listed after 3 weeks.
3 weeks.
Yes.
May I please, your lordship, I beg to mention item number 17. 17. Yeah, I am for the respondent.
17.
17. This matter may be adjourned today and may be listed after 2 weeks.
You're for the petitioner.
I am for the respondent.
Respondent.
Yes,
Anybody for petitioner?
I have informed. This morning I have informed. Obliged.
May it please, your lordship. Lordship, I beg to mention item number 9. Here,
Nine.
yes, your lordship. I'm seeking some accommodation on this matter. A 3 weeks time may be given to us.
3 weeks.
Yes, your lordship.
You're
Some-
Mr.
I'm Mr. K.M. Mahanta. Obliged.
3
Your-
weeks.
Yes, your honor. Obliged.
My lord, I may be allowed to mention item number 17.
17, somebody said. Somebody already.
Okay, no much. And item number 21 and 22.
You're for the petitioner?
In item number 22,
Appellant.
item number 22, I am for the appellant. And item number 21, I am for the respondent. So I have taken consent from the opposite parties.
You're Mr.
T. Omo, on behalf of B. Kosik, Tapi Omo,
B. Kasrik.
Kosik. After puja break.
May your lordship, I beg to mention item number 15 on behalf of B. Kaushik. Your Honor, matter may be adjourned for today and this is after 3 weeks.
The other side,
Other side, I have taken consent.
so with the consent of other side, huh?
Okay.
May I lordship? I like to mention item number 11
Yes,
on behalf of T. Tapak.
on behalf of,
T. Tapak. Here is already there.
you're Mr.
And B. Sivo. 4 weeks.
4 weeks, okay, 4 weeks.
I'm sorry, your lordship, interim was there in item number 15, so interim may be continue. Okay.
My pleasure, my lord.
Yes.
My lord, the impugn order before the lordship is order passed by the session just on 14/8/2023 in the morning appeal number 2 of 2023. Whereby, my lord, the order has been passed. My lord, on the ground that the no IA has been filed for condemnation of delay, my. That is only the reason, ma'am. So, my lord, before come to the impugn order, I will take the lordship to the page number 69.
16,
69.
69.
Yes.
Money, sir. Money, sir.
Manisha,
16.
this is the morning appeal. My lord, 69.
69, yes.
This is the order of 13/7/2023 when the this money appeal was moved for the first time. That, my lord, by this, my lord, order, what it said that the appeal is filed under section such and such on the section clause. with a prayer for quashing of said and the judgment order dated 5/4/2018, passed by the Civil Justice Senior Division UPA in money suit number such and such by the degree was passed ex parte against the appellant, further prior to steady execution of the execution number 10 of 2018 under section such and such till the final disposal of the matter. Or Mr. such and such for the appellants and peruse the petition. Let the notice be issued to the respondent as to why the prayer shall not be allowed, shall not be as prayed for. Call for the LCR scheme scan from the Lanet Court of the Civil Justice Senior Division. In the circumstances, execution petition number is stated against the present appellants as the dependent number 1 in original suit till original suit number 102 of 2005. Accordingly, the next date is fixed for the reply hearing on 18 of
So I'm
14/8/2023. My lord, meaning is very clear that after hearing that the impugned order interim was granted, my lord. Now, my lord, my lord may come to the next page, 70. This is the impugned order before the lordship, page number 17, 70.
70?
70. Yes, next page, my lord.
Okay. On 14.
Mr. Sasha appear in the present who has filed this money appeal against the impugned order passed by the Lord number such and such on 5/4/2018 and was paid for staying of the education order by the learned Civil Justice number such and UPA on 18/5/2018. After hearing the learned counsel and the provision of the impugned order, it is found that the impugned order were passed in the years 2018 and the learned counsel for the appellant has not filed any misapplication with prayer for condemnation of the delay of above 2 years. Therefore, the appeal stands dismissed on being not maintainable. Now, my lord, before the lordship, why this order, particularly 14/8/2023 should be set aside, my lord?
In connection with the same order, same case.
Yes. So, my lord,
The execution was stayed earlier.
yes, on the, my lord, previous occasion of 13/7/2023, that was already stayed. And that was, my lord, stayed by the other judge. But in the meantime, my lord, the session judge has been transferred, and now the other judge has come, and without going into the record of the case, my lord, where it is the impugned order said that, my lord, we have been praying for, my lord, stay of the execution order, whereas it has already been stayed, my lord. Now the second ground is only that no application has been filed for condemnation of the delay, my lord. But whether there is a requirement of the application condemnation in this case or not, that was already been decided in the earlier case, my lord. So, my lord, for the reference of this honorable court, I will take the lordship to, my lord, may kindly come back to the page number 22.
This 22.
My lord, this is my appeal before the appellant prepared by application is not barred by the limitation such and as such. The same is being filed within the limitation period as per the section 12 read with article 123 of the Limitation Act 1963, as the appellant came to know the degree on 1/6/2023. What is the facts behind the case is, my lord? I come to know that an education petition is going on against me, and I come to know the same thing on 1st June 2023, and accordingly,
The original decree was passed on which date?
original degree was passed on, my lord, 5 April 2018,
5 April 2018.
my lord.
So in execution matter, order 21.
Yes,
just in 2 years, you have to file an appeal, a execution proceeding.
my lord, that is the view who is been taken by the, my lord, district judge. But what I am trying to convince this honorable court is that in my case, the limitation period was not barred under the Article 123 of the Limitation Act, my lord. Where in the Article 163 of the Limitation Act said, my lord may kindly have a glance with the 123 of the article, my lord. Limitation article, my lord.
123.
My lord. My lord, got it.
123, yes.
My lord, page started. Where it is said, my lord, to say this at the degree past ex parte or to rehear the appeal and degree or hard ex parte, my lord, there is 30 days. And the 30 days, my lord, commence from the date of the degree or where the summon or the notice was not duly served, when the applicant had knowledge of the degree.
Yes.
So, my lord, my contention is that, my lord, I came to on my, it's come to my knowledge on, my lord, 1st June 2023 only. And accordingly, my lord, I have applied. And after applied that, my lord, the copy was furnished to me on 27 June, my lord, may record 27 June 2023. Therefore, my lord, the computation under section, my lord, section 12 of this limitation is, my lord, shall not be counted. So the computation period will be start from, my lord, 27 June 2023.
That will.
Therefore, my lord, my case was not barred.
It's the first day, so issue notice.
My lord. And in the meantime, my lord, the impugn order be stayed, my lord. Otherwise, my lord, the execution is going on.
Because it's a matter of dismissal, no?
My
So other party you have to hear, no?
That is true, but my lord, I have established the prima facie case, my lord. My lord, this is the case. If,
It's a matter of.
my lord, if
dismissal.
interim is not considered, my lord, the execution will goes against me. And I will be, my lord, arrested by
It was
someone.
dismissed. So why the execution is going on? The case was dismissed.
My lord, the case has been, the appeal prepared by me against the execution is dismissed. Therefore, my lord, execution is going on, my lord. So, my lord, at least up to the next returnable date, my lord, this interim need to be, my lord, I need to be protected.
Under section article 227 of constitution with 115 of CPC. Against the for washing of the against the impugned order dated 14/8/23 passed by the Learned District CGPF in connection with money appeal number 2/23. Issue notice to the respondent. You have sole respondent, no?
My lord.
Issue notice to the respondent. The petitioner shall text it on service of notice to the respondent. With the registered ID as well as serial process returnable within 4 weeks. Steps be taken within.
My prayer in page number 14, my lord.
It's a matter of fact, no, whether you have received notice or not.
My,
So we cannot, after hearing the other side.
my
The
lord,
next day on hearing on appearance of the other side, the prayer of stay will be considered.
my lord, one thing, my lord, till the next
Because
day,
it
my
is
lord,
difficult.
everything will be over, my. The matter will be in process. Because in due course of the time, if I will be summoned and I will be arrested by, if I will be compelled to, my lord, comply the court order in the execution, my
It's
lord.
a question of maintainability is there, so it's difficult to stay the matter at this stage without hearing the other side. Yes. The matter of stay will be considered on the next day after hearing the other side. So you can take steps immediately and if possible.
Yes,
to
my
serve
lord,
notice.
my lord, I will take step by dusty, and so matter may be listened next week, my lord.
That's the matter. That's the mode of service. The body shall, after service, will file an affidavit to this on that. So list the matter after 1 week,
My lord, one way,
after.
all right.
Yeah, please, your lordship, I am filing. I'm appearing on behalf of the victim to assist the people.
We are appealing for victim.
Yes.
For 38.
Yes, may I please lordship? My lordship, it is a anticipatory bail application, lordship. Lordship. Before this lordship, it has filed learned district and session judge UP lordship, bail was rejected lordship.
Case number,
It's a annexure 1 lordship, page number 9 lordship. It was rejected on ground lordship that initial stage of the case lordship.
CD was not called, for.
No lordship,
CD called for, CD was called for. Peruse the city. It's a habitual offender. Section
section lordship 34 and 226 IPC lordship.
326.
326 lordship, yes.
Where is the FIR?
If I may, I read lordship FIR copy.
Page number,
Annexure to lordship,
page number.
page number, type copy is 15 lordship, page number. Last one lordship.
So CD is not received, I think.
No, today only motion state lordship. Today notice may be issued and scan copy of the CD may be called for.
Notice, why notice is
No,
good?
because,
Yes, I already appeared.
Yes, lordship. For her, for him lordship.
That lordship, the fake of case that lordship, it was a disputed arises lordship. That
Call for the case study, after perusal of case study and the injury report.
yes, one.
Bill application for 38 CRPC.
Lordship interim may be granted lordship.
To grant a pre-arrestment who is apprehending arrest in connection with Itanagar case number 200/23 under section 326/34 IPC. Call for the case diary along with the injury report of the victim. Date please. You, Mr. K. Tara. Okay. is appearing from the informant or victim? Victim. Okay.
Lordship,
Yes, date, please. 20? 25.
Lordship, interim may be granted. Much of it.
Yes.
It's same lordship, they are co-accused lordship
Who accused to us? So same order, no?
of license.
May I please, my lord? This is an application criminal petition, my lord. Under section 482 of the CRPC for causing of the FIR being Hailung.
Charge sheet also.
Yes, or no, charge sheet also, and entire proceeding whatsoever going on. In this case, my lord, I would like to draw the attention of my lord upon page number 20. That is the type copy of the FIR.
302.
Yes, or no? Page number 20.
20.
Yes, type copy of the FIR.
Yes.
Yes.
FIR, no?
Yes, this is the FIR. On the basis of suspicion, only on the basis of suspicion, this FIR was lodged against two accused petitioners who are moving this criminal petition before this honorable my lord court.
Two persons, no? Two petitioners.
Two petitioners, yes, my lord. Two were named in the FIR that they were committed the offense as alleged against them. Now, my lord, in this case,
Yes.
I would like to draw the attention of this honorable court upon page number 44. That is the type copy of inquest report.
24.
44. 44.
Yes.
In the inquest report, my lord court will found that date and time of inquest 17/8 at 16 hours.
79.
Page number 44, my lord.
22.
44.
24. Yes.
44.
Memo of arrest.
44. Page number 44. Inquest form.
Inquest.
Inquest.
44. Yes. Name of the deceased.
Inquest form.
Yes.
The date and time of inquest 17/8/2015. And description and condition.
Yes.
Position and condition of dead body. The body found lying with face towards the sky and head down north. The dead body partially decomposed and may got formed in body. Description of clothing wearing appearance found in the body. Deceased wearing one half pant deep as color. And thereafter no any other descriptions. And in next page, my lord found.
Where?
In the next page, my lord, in the next page.
Yes.
Multiple located owned with fracture skull, one trunk, multiple bruises fracture on right hip bone, on limbs, no injury, back side of body, multiple located owned with fracture of skull, and mark over back multiple bruises abrasion. Now, I would like to draw the attention of this honorable court on page number 57. 57.
Huh?
57, my lord.
57.
57.
57.
57. This is the IO IU requisition letter to the magistrate for appointing or deputing a medical officer for conducting this, my lord,
Postmortem.
postmortem, for conducting postmortem and inquest. Now here in this case, one thing I would like to draw this attention. I have the honor to inform you that inform you that Danglur Belai was involved in kidnapping case number 20 of 15 under section 366 IPC. In fact, my lord, the deceased was involved in a kidnapping case of the wife of the one of the petitioner, my lord. The petitioner number 1. Petitioner number 1. That's why he was suspected and involved in this case. Now, I would like to draw the attention of the on page number 82. 82 regarding the PM report. Eighty-two, that is the type copy of medical report. As per the opinion formed by the concerned doctor, my lord, found by the postmortem examination and finding of late Dagralum Bilai, age 40 years, male.
Where is it? 80?
Page number 82 in the last column, my lord.
52. Yes.
In the last column, my lord.
Yes, cut injury, no?
Yes, my lord.
Cut injury on left upper arm. Multiple lacerated wound of skull. Yes.
Opinion of the surgeon who has conducted the PM. Type copy, my lord.
Yes, type copy.
82.
Page 82, yes, got it. Type copy.
Opinion by the postmortem examination and findings
Yeah.
of the late Daglalum Bilai, age 40 years, male. I am of firm opinion.
Where is it? Nothing is there. Page 42, 82 only cut injury on it, that is in injury column.
82, 84, my lord.
82.
84.
84.
80.
My 84 is the charge sheet. 82 is the inquest report.
82 is the postmortem report.
Yes.
Postmortem report. 82 is where the last column is where he is pointing to you.
Yes. Last column is healthy vessels, heart and so and so. And injury, that is cut injury on it upper arm, multiple lacerated wound of skull, that is there, nothing else.
The next page, your lordship, in that.
Next page,
Yes.
that
Down.
is a charge sheet, I think.
Your lord, they might not have skipped
The
the.
prosecuting story of the case is so and so. Anyway, it's a case of 482, not washing.
Yes,
So
your lord.
call for the case, I think.
Your lordship,
This
this,
charge sheet has been submitted.
the
My
charge has
lord.
also already been framed and 19 witnesses has already been.
19
framed.
witnesses have been examined,
19.
Yes. your lordship.
19.
There are 25 witnesses, your lordship.
but nothing has been come against the accused persons. Nothing, not a single allegation put forward against the petitioners, my lord.
They are on bail.
They are on bail. They are on bail. My lord, unnecessary
So wait
since,
for the trial, that is
Yes.
better. I
my
guess.
lord, unnecessary since the year 2015. Last 8 years,
How
they are
many
facing the trial,
How many witnesses?
25 witnesses.
There are 25 witnesses, your
25
lordship.
witnesses.
19 has already been examined.
Unnecessary, my lord. Unnecessary, the trial of this case is proceeding.
So
in court.
LCR along with the evidence statement of the
Yes,
witness.
yes. Cane copy of the LCR. your
Can-
lordship.
My lord, my further prayer till disposal of this on my lord criminal petition,
No,
the stay may be granted.
482 CRPC. Praying for quashing of the case. The case number that is pending, where it is pending,
Session case number 4, ANG of 2019, page number 3
page number,
of petition. Criminal petition.
It's pending in sessions court. Teju.
Yes.
page number 3.
Three, my
Page
lord.
number 3 is not there.
In the first page also it is written, my
No,
lord.
no. Sessions case number 4, Anjao of 2019.
19.
ANJ, no?
ANJ.
Sessions case number 4 in bracket ANJ of 2019. Pending in before the Court of Sessions Judge Teju. For the scan copy of the record. And the statement of the witnesses recorded so far. Yes, date,
Your lordship, also notice may be sent to the complainant, your lordship,
complaint, yes,
after 4 weeks.
4 weeks. Respondent to, no?
Yes,
Issue notice to respondent to. And an additional 50 has appeared on respondent number 1. With registered ID, usual process. Returnable 4 weeks. Petitioner shall take steps.
deeply.
My lordship.
This is for admission. My lord.
Admission.
That day I have raised some question on maintainability of this revision petition. And I have not filed the affidavit yet, but then on the basis of their revision petition itself, everything would be clear, my lord, that this petition is not maintainable.
They have to file affidavit. If they had issued, raise their own maintainability laws.
Yes, please.
They have to file affidavit laws.
No, my lord. From their petition itself, I'll argue.
Okay. My lordship. My lordship.
Yes,
Lordship, kindly take lordship annexure 3, page 41,
page 41.
41.
Yes.
This is the general power of attorney, lordship. Executed on 19/11/2015.
1911,
2015. I am the proprietor, lordship. King of Thais, lordship. And the next is lordship, annexure 4, page 46, lordship.
46.
46, lordship.
DWs.
DWs, lordship. 6 November 2019, lordship.
It's not legible.
Type copies at lordship.
Page 46 is DWs.
Yes, lordship. Type copies at page 53.
Lord. 53, yes.
53, lordship. Your living would be lordship, page 54.
Page 50, yes.
54, second paragraph.
Second para.
Second. Married. And whereas the lessor has agreed to grant and lease, lessee has agreed to take on lease the said factory, including plant and machinery, etc., install or otherwise therein both movable and immovable for the period of 10 years. Commencing from 1st November 2019 at the annual lease rent. And thereafter, lordship, another lease agreement was executed between the parties. Kindly see page 60, lords.
Yes.
60.
The second lease agreement.
Second lease, lords. 2015 general power of attorney. 19 lease, 20 lease, lords. There are 3 documents, lords. Lease agreement, lordship, page, kindly take lordship, page 60, lordship.
60, yes.
60.
62,
60.
60, yes, 60. Got it.
The limit will be lordship, page 61,
61, yes.
married, lordship.
Yes, yes.
Second para. Finding the term and condition suitable by the first party, the second party has heartily accepted to run the factory on annual lease rent of rupees 18 lakhs, lordship.
18 lakhs.
18 lakhs per year to the lessor. In case of failure to pay the lease rent per year, lordship, as agreed time period, the lessor shall serve 30 days notice, lordship, to the lessee to vacate the factory, that is machinery and premises, Thus, in the event of failure to pay the lease rent on time, the lessor shall withdraw the power of attorney from the lessee without any other further notice. Without any other further notice, followed by the removal of raw material from the factory premises. Lordship. Now, Lordship, the respondent has violated the sum of the violated the condition of this lease agreement, and there is pending criminal cases against my factory. Lordship.
You are
For-
the respondent here.
Yes.
Respondent, that is the petition.
Yes. For this reason, I have terminated my power of attorney, Lordship. Revocation of power of attorney, Lordship, page 63, Lordship. 63. They had Lordship, page 63, Lordship.
Yes, yes.
By deed of this revocation, Lordship, I have terminated my general power of attorney dated, Lordship, 19/11/2015, Lordship.
Nine,
Page 65, Lordship, type copy. 65, Lordship.
9th of February 2020.
Yes, sir.
That is a revocation.
Yes,
Of
yes.
both the power of attorney.
Yes, I have served the notice. And they have
But you cancel the job.
Yes.
Power of attorney.
been
So
agree,
You've executed two power of attorney
yes,
earlier.
Yes.
So by this deed of revocation, you have revoked both the power of attorneys earlier, 1 and 2.
Lordship, in 2015, there is a power of attorney. Kindly say,
Two
Lordship.
power of attorney, you have stated
No, no,
about
no.
that, two power of attorney,
Two lease agreement, Lordship.
two lease deed,
Yes, sir, lease deed.
two lease deed, but one power of attorney.
Yes, yes, one power of attorney, 2015, Lordship.
So that is revocation.
I have revoked, Lordship. Being agreed of this revocation, they had prepared, Lordship. Title set, Lordship. Kindly see, Lordship, page 66, annexure 6, Lordship.
66, okay. 108.
They had filed, Lordship, prepared titles with under section 108 of transfer of property Act, Lordship. Lordship, kindly take, Lordship, page 76, Lordship. Internal page 11, Lordship.
76,
76, Lordship.
yes, 76,
76. Internal page 11, Lordship.
page 11.
May, Lordship. Kindly see, Lordship, para 16, Lordship.
Para 16 is.
May, Lordship. That the petitioner begged to state that this honorable court has jurisdiction, Lordship, to entertain the present petition as the agreement was entered into and executed at Changlang. Further, the cause of action also arose within the jurisdiction of this honorable court. No mention of the pecuniary lordship jurisdiction, Lordship. And kindly see, Lordship, page 79. Dear prayer,
Is it 79,
79, prayer number 2, Lordship.
yes,
An amount of rupees 8 lakhs only to be paid to the petitioner by the respondent as to compensate the damage, Lordship.
let's say the damage.
Yes, yes. For the damages, they had claimed 8 lakhs in main suit, Lordship.
Revocation of deed, yes.
No specific averment of the pecuniary jurisdiction of the court. And while filing this, they had filed another application, Lordship, under order 39 for injunction, Lordship. Page 113, Lordship,
113,
113. Annexure 7 series, Lordship,
113.
113. This is application under, Lordship, order 39, rule 1 and 2 for the injunction, Lordship. May lordship kindly take lordship page 124 lordship.
120.
4.
Yes.
Internal page 12 lordship. Para 20 lordship.
Para 20 years.
Married. That for the purpose of the pecuniary jurisdiction of this court, the suit is valued as rupees 5 lakhs lordship. In the main suit, they had not made any specific averment regarding the valuation of suit. And only in the prayer, they had claimed 8 lakhs as a damage loss. In interlocutory application, lordship, for the injunction, they had stated rupees 5 lakhs lordship. And by cases, lordship, this present suit is pending trial before the civil judge senior division lordship. And learned senior civil judge senior division has no jurisdiction lordship as per the Arunachal Pradesh Civil Court Amendment Act lordship 2021. Civil Court lordship. Page section 14 lordship.
Section
14
1/4.
1/4. Married lordship. The jurisdiction of civil
Wait, I didn't get it. Para.
page 3.
Page 3. Page 3. 14.
Section 14 lordship.
Jurisdiction of civil court.
Jurisdiction of civil court of civil judge junior division lordship.
Okay.
The jurisdiction of court of civil judge junior division shall extend to all original suits and proceeding of civil nature and subject to the provision of Code of Civil Procedure 1908 or any other law lordship. For the time being in force, the pecuniary jurisdiction of Court of Civil Judge Junior Division shall extend to all civil suits which do not exceed rupees 10 lakhs lordship. Or as may be prescribed. Suit is pending before the senior division lordship.
Senior division.
Senior division.
Then
Yes,
senior
lordship.
division definitely.
My case is that it should be filed before the junior division lordship. Without the jurisdiction lordship,
It's from decree.
the trial is going on lordship.
So that is not specifically mentioned, what is the jurisdiction of civil judge? Definitely more than 10 lakhs.
Yes, lordship.
Senior division is having jurisdiction over 10 lakhs
10
and
lakhs.
above.
Yes, and- yes,
If
and
it
then
is specifically
Being
mentioned.
situated thus, my lord, your lordship, this title suit is pending before the senior division,
Senior division.
not before the junior division.
Junior division.
That may be kindly taken note of.
So regarding jurisdiction, it is. Because that is senior division. Senior division is more than 10 lakhs.
Yes, lordship. In the main suit, they had only claim for the 8 lakhs lordship.
8 lakhs.
8 lakhs in application lordship under order 39. They had categorically made the averment of rupees 5 lakhs as a pecuniary of jurisdiction.
10 lakhs.
Yes, sir.
So your prayer is.
Either it is
That is
5 lakhs or
junior
10
division.
lakhs, junior division lordship, my case. lordship.
Okay.
The learned senior civil judge senior division lordship. Yes, pass the lordship,
Where is the order?
impugn order lordship, impugn order is at lordship. Page 36 lordship.
Page 36.
36.
Seven, 12, 22.
Yes, Lordship. Whereby my application under order 7/11 has been dismissed, Lordship. I had filed application for the rejection
You
of.
were there, I mean, opposite party there.
Yes, sir.
You were absent.
Opposite party is the respondent hearing person.
Respondent.
Yes, sir.
You were the petitioner here.
Petitioner, defendant person. Kindly see the second line. I am the defendant in that itself.
So during the argument, you have not taken the plea regarding jurisdiction of the case.
I have taken the plea. Lordship. I have also filed Lordship. Written statement has already been filed. Now the suit is at the stage of issues and documentation. My only grievance is, Lordship, without the jurisdiction, if the
Only
trial
on
goes,
jurisdiction. You have
yes,
not taken the plea only on jurisdiction.
I have taken the plea, Lordship.
During that period, there is argument you have taken.
Page 154, Lordship. That is my application, Lordship. 154, Lordship. 154, annexure 9.
154.
On this, Lordship, impugn order is passed. Annexure 9.
154.
154.
154 is the petition,
Yes, Lordship.
order 7, rule 11,
Yes,
for rejection of claim.
rejection of terms. One 56, Lordship. Kindly see Farah 7, Lordship. Merit, Lordship.
Yes, yes.
That the humble dependent beg to state that the relief showed by the plaintiff cannot be granted under the law, Lordship. Under the law, Lordship. Civil Court Act has been, Lordship, amended, wherever there is a specifically mentioned, Lordship, of the pecuniary jurisdiction of the each court.
Yes.
I have already given, Lordship, Arunachal Pradesh Civil Court Act, Lordship. My lordship,
So you have filed the petition against the order of 7/12/22.
yes, Lord.
7/12/22. You have filed this petition,
Yes.
filed this petition.
Yes, lordship. 7/12 and lordship
7/12/22
and
and
lordship. Annexure page 135, lordship.
7/12/22 is 36. That is the order of this court,
Yes, Lord.
Court of Civil Judge.
I have challenged lordship. The title suit also, lordship. Admission of title suit lordship also.
Admission of titles,
Yes, lordship. Page 130, lordship.
130.
Yes, lordship.
130. 130.
130, lordship. Annexure 7 lordship.
21.
This is order dated 21/2/2022, lordship. Whereby title has been admitted, lordship, and 8 interim ex parte order was granted, lordship.
Only in the matter of admission, no?
Yes,
Anything you want to say?
Okay, may I?
Yes.
Your I'll not take much time, my lord. So, my lord, basically, if suppose order 7, rule 11, any application is filed, like in this case, they have filed order rejection of claim. If that got dismissed, there is a provision of appeal, which they have not done.
Provision of appeal or revision?
Appeal,
Order 7, rule 10 or
rule
11.
11,
Rule 11, that
Rule
is
11.
rejection of. claim.
rejection of. And even order 39, rule 1 or 2 or 4, any order is passed, there is a provision of appeal, not revision. So in view of the matter, the two prayer in this petition, it goes.
Only in matter of appeal, no?
Ah. Kindly that may be taken note of. Thereafter, my lord, had it been this title suit, this respondent plaintiff, had he filed this title suit before the learned civil judge junior division, then my learned brother would have been a very good case, my lord. But since civil judge junior division is not posted in the district of Changlang, only there is a civil judge senior division available at Changlang. So considering that aspect, this respondent plaintiff, he filed this title suit number 1 of 2022. And what Civil Code Act 2021 says, Lordship has correctly understood, I believe, is because up to 10 lakhs, the jurisdiction, pecuniary jurisdiction will be of civil judge junior division.
Oh, yes. Which
And they are
not
trying-
exceed 10 lakhs means up to 10 lakhs.
Up to 10 lakhs by civil junior
Junior
division.
division.
And this matter is pending before the civil judge senior division. So therefore, in the absence of or in having not been posted of any junior division in that district, normally we used to file before the civil judge senior division in all such type of cases. Though it may be
Civil judge junior division has not been posted.
not being posted.
Okay.
Had it been posted there in Changlang, definitely we would have been filed there in the before the civil judge junior division.
The post is still vacant or there is no any post?
Post is there, but then no officer is posted yet.
Posted.
And now, regarding pecuniary jurisdiction, like for example, your lordship may kindly take a note of. If suppose for trying any offense, my lord, if suppose like there is a differences in the capacity of imposing penalty in between chief judicial magistrate and the judicial magistrate first class. That is imprisonment up to 7 years that can be passed by the chief judicial magistrate also. But
Yes, magistrate also.
no, magistrate cannot be
7 years.
7 years. Judicial magistrate first class as per CRPC. So why I'm trying to giving that I'm trying to give that example,
JMFC also.
JMFC also. Anyway, to my humble understanding, there is a variation in imposing sentence between judicial magistrate first class and chief judicial magistrate.
29.
So why I am giving that example, my lordship, because this is not the case that
Civil matter.
civil judge senior division is not having the jurisdiction. Had it
Is there any notification of the Honorable High Court of this court that civil judge will take up the matter if there is no jurisdiction? That's the point.
there is, I suppose, but then I have not placing that. But then normally we used to practice that only. Otherwise, we'll be without having any forum.
Definitely there will be something.
My lordship, junior division is posted at the council lordship, at the jurisdiction of district and district judge councillors.
Konsa under Changlang?
No, it-
Changla council, different district,
Different
but there is a junior division at councillors. That may be recorded.
That is different district, my lord.
Okay, different district.
Different district. So, my lord, this is not the case that senior civil judge senior division does not have the jurisdiction. What they are saying is that senior judge civil judge senior division has the jurisdiction, but since the pecuniary jurisdiction as per our statement is 5 lakhs, sometimes 8 lakhs, since that is within 10 lakhs, then that should have been filed before the junior division. So how can senior division would not be having the jurisdiction by law? Therefore, on this third count, this revision petition is not maintainable to my to my humble understanding. On that to expect
Okay.
Other
Anything
prayer?
you want to say about regarding your petition, that is rejection of claim?
Yes.
You have to.
there is a
put this
provision of
appeal.
appeal.
You
And
have to prefer
even
an
for
appeal.
injunction, there is a provision of appeal in
Or
CPC.
39 rule 1 and 2.
No, lordship, as per my understanding, lordship, revision would be less. Lordship, revision would be less, as per my understanding, lordship.
Notification is there.
Yes, lordship. As per my understanding, lordship.
So you want to say anything, whether
Yeah.
revision lies or not,
My lordship,
regarding rejection of plaint or order 39 rule, I mean injunction or.
my lordship, I had challenged the lordship, the admission of the title suit itself, lordship.
Yes, title suit,
Yes, lordship.
admission.
If you authorize lordship two, lordship. The rejection of plaint under order 7, rule 11,
Rule 11.
and admission of the title suit itself, lordship. By this civil judge senior division, lordship. Lordship, under the jurisdiction division of the district judge council, lordship, there is already junior division posted at the council, lordship.
If there is no any civil judge junior division, the civil judge definitely there has been any alternative to file a petition.
As per my little understanding, lordship, Civil Court Act has been amended, lordship, came into force, lordship, whereby specifically mentioned the jurisdiction of the pecuniary jurisdiction of the junior division
Where it says.
civil judge, junior division of 10 lakhs, lordship.
That's a rejection of plaint, no? The order dated 7/12/22 is rejection of plaint. Where
Rejection
the
of-
revision lies. You filed a preferred and revision here,
Yes, lordship.
115 and
Kindly, lordship, 130, lordship,
1,
annexure 8, lordship.
130.
No, 135, lordship of my petition, lordship.
134. Page 134.
Yes, lordship. One 34, lordship.
Yes. That is against the order 21 to 22.
Yes, lordship.
That is order 39, rule 1 and 2.
No, lordship, this is the order
So-
where, yes, whereby the
Next.
plaint has been accepted, lordship. Page 130, lordship,
130.
130, lordship.
Yes,
Order dated 21 to 2022.
20.
I have also challenged this order, lordship.
You're the respondent there or plaintiff? You're the
Respond,
respondent,
dependent,
defendant in the main suit. And in this application, you're the petitioner or defendant
Petitioner,
in
applicant.
39. Order 39,
Order 39, I am Order- the applicant. Plaintiff is the applicant.
plaintiff is there.
Applicant. And for the rejection of plaint, they are the applicant. He is the applicant.
dependent is the applicant. Page 130, lordship.
So that is not a final order, no?
Yes, lord.
This 21 to 22. There we revoke the addition. So general power of deed of revocation was stayed.
Yes, lord.
The order was first in favor of him
No, in favor,
against the,
yes, against me.
your bank account was also
Please,
closed. That was open, you were allowed to operate
Yes,
the
yes.
bank account, no?
plaintiff is now allowed to use the same. lord.
Well, say. I'll pass the order.
Highly ordered.
May I please, my lord? My lord, I am honestly submitting, I am here to. My lord, I am here to comply the order passed by reasonable court on 27/7/2023. So, my lord, let this matter be taken up after 3 weeks,
After 3 weeks.
my lord. And at the same time, my lord, one thing is, since this is the, my lord, old case, registry may directed to, my lord, prepare paper book, my lord.
Paper book.
My lord,
It's a appeal or revision.
my lord.
What
This
is
is
paper?
criminal case.
Huh?
In case of my lord, criminal appeal, my lord, the paper books are normally prepared by the register.
Yes, in case of, it's a revision, not
Revision.
appeal.
And
LCA.
is step in respect of respondent 2 and 3, not yet completed. Petitioner was directed by the court to take.
2
first
and
step.
3.
Yes,
2 and 3 now.
one is informant and another is victim.
The revision against conviction.
My lord.
2 and 3 not appeared.
My lord, I will comply the order passed in 27 July 23. So, to take the brace step forward, my lord, consult police
Take
step.
steps on
Mal.
2 and 3. And so and so, so and so. Issue fresh notice to the, fresh notice, no?
My lord, through the consult police station. my lord.
Respondent 2 and 3. To concern police station. Registered AD as well as usual process returnable within 3 weeks.
Okay.
Steps be taken within 7 days. Let the matter. Say,
My lord, I have taken the step, my lord. And service was goes through the police station 0. my lord. So now the report is awaiting. Yeah. Report is awaiting, my lord.
Report is everything, but service was in wrong address. Your Worship.
yes,
In wrong address. Respondent number was issued notice on in wrong
2,
address.
3 and 4, no?
Yes,
2, 3 and 4.
there are 2 FIR, one lodged by the victim, another one by deceased family members.
One is headmaster is there.
Headmaster to ascertain the birth, date of birth in the school
This
register. Three and four, sorry, 3 and 4,
3 and 4.
yes,
2,
4,
2 has already appeared.
yes,
Yes,
2 are already
yes.
appeared.
Already,
Appearing, yes,
okay.
and 4,
4 newly impleted, I think, no?
4 yes, sir,
Yes.
completed.
Newly impleted.
As per order dated 3/11/2021.
You have not taken steps, no?
I have taken it.
You have taken steps?
Yes.
But in wrong address. Sir. Thereby it is written that permanent resident of village Tajang,
Okay.
but in the
So wrong address.
wrong address.
You have collected the correct.
In the
one.
FIR, there is a address, proper address. Hapoli, he is a resident of Hapoli.
Third, Mr. Swanson, I have counsel for the petitioner, now add additional PP. Submit for the state respondent 1, none appeals for the respondent 2. Regarding respondent 3 and 4, issue fresh notice. With registered AD, usual process, the correct address of that. In their correct address, through OC concern place. List of 4 weeks.
My lord. All right.
Yes. Well. Well, anybody?
Council, not there. Service is completed or not?
None appeals for the, no steps taken also. None appeals for the petitioner, none additional PP is present on behalf of the state. List the matter after 2 weeks.
Your Lordship, we have taken a step through police station to respondent number 2. and AD card have not been received.
You with service report, no?
Yes, yes.
Yes.
So and so, ever service report regarding respondent to.
Lordship, interim may be continued.
There,
Yes, interim.
interim is extended till the next date of. Yep. Fourteen. More than 1 year, not yet, no? Disposed of, none appears for the petition. On call, it appears from the. Proceed that for more than 1 year, petitioner is not present. The learned counsel. The petition is dismissed for non-prosecution.
Madam, item 16 is a review petition, my lord.
16.
Yes, madam. It's a review petition, my lord. My lord has disposed the matter. It was a civil revision petition. My lord has remanded the matter back to the deputy commissioner, my lord. And my lord, since this judgment was passed in the principal seat, maybe otherwise we could have appraised this honorable court that after the coming into force of the Civil Courts Act, AP Civil Courts Act, the power vested on the deputy commissioners have been taken away, my lord. My lord will kindly see the relevant direction at para 24.
24.
Yes, my lord. After hearing the learned counsel for both parties, it reveals that the allegation made by the petitioner that he was not given an opportunity to hear before passing the order dated 23/12/2019 by the Deputy Commissioner Alo. The matter in dispute relates to a plot of land claimed by the parties, whether it is located at Pakeneru or Loglu. Deputy Commissioner Alo is directed to inquire the matter thoroughly regarding respective claims over the disputed land after proper identification of the land and if required with setting up a commission. The case is remanded back with a direction to the Deputy Commissioner Alo to adjudicate the matter afresh and after hearing both parties on dispute pass order accordingly. And in this,
The matter was remanded.
yes, my lord. My lord, what happened, my lord? My lord's judgment is of 21/11/2022.
21/11.
2022.
22, yes.
Yes, my lord. By this time, the powers of the Deputy Commissioner under the earlier Assam Frontier Regulation was taken away.
Okay.
And the Civil Courts Act has come into
Yes,
force. And therefore, my lord, if my lord will kindly take up the AP Assam Frontier Regulation. Earlier, my lord, in the Assam Frontier Regulation, the appeal from the village authorities, from the decision of the.
During your argument, you have stated so, the matter.
Yes, remanded back, appropriate forum, my lord. Appropriate forum would have been the civil judge, junior division or the civil judge.
No, in that way, that is not possible. So you have to file a fresh case before.
No, my lord, here is a case, my lord is remanding. Earlier, when that matter under the Assam frontier, this appeal was heard by the deputy commissioner. And the order was against the order, this revision was,
You have filed this revision against the order of the deputy commissioner. Yes,
the petitioner has filed. I was the respondent.
you are the respondent.
Yes. I was the respondent. Petitioner has filed against the order of the deputy commissioner. At that point of time, when the civil revision was instituted in the year 2019, the deputy commissioner was having the power.
Having the power now.
Yes, during the pendency of the civil revision, the power vested on the deputy commissioners were taken away by the enactment of the AP Civil Courts Act. And therefore, appropriate direction would have been to remand the matter.
Issue notice.
Yes, my lord. And in the meantime, my lord, since this is creating a problem, because the deputy commissioner also, they know that nowadays they don't have the power. But this is, there is a direction by this honorable court. In any ways, they have taken no action, my lord. We have written, we have filed a review for correcting this, my lord. Notice may be issued, my lord, for today. And in the meantime, this may not be given effect, my lord. Otherwise, it would have been easy when the judgment, before the judgment, this we could have clarified.
Mr. Consulane Council for the petition. Application under section 114. 43.151 CPC. Review the judgment and order dated 21/12/11/22. Passed in civil revision petition number 03 in bracket AP/2020. Issue notice to the opposite party. The earlier the advocate who represented the.
Yes, I have requested him also. Even he knew that I had.
Dispose of the matter today also if he has.
If my lord may issue notice because he's not present today. Otherwise, I could have asked him to represent.
Issue notice to the opposite party. The petitioner shall accept some service of notice. Registered in the legal process, returnable within 2 weeks.
2 weeks.
Place the matter on. After 2 weeks.
After 2 weeks. Well, in the meantime, this may not be given effect to
Yes, ma'am.
the my lord's order, my lord. That the order will be subject to outcome of this revision petition. The impugned order.
After hearing the other side, it will be better, otherwise it is difficult.
Because
it's
otherwise-
a review matter, no?
Yes, my lord. That's why this will be
After
subject.
hearing the other side, it is better if this time it will be possible.
My lord may
I am
only
leaving 22.
observe
Before
the
that, if possible, I will take up the matter. I am leaving 22, so possible.
my lord may only observe that this order of my lord will be subject to the final outcome of this review petition. That much, because
Okay, that must be good.
subject to the order will be subject to the outcome of this review petition.
Subject to order of,
The outcome of this review petition.
so definitely.
Yes, that will make it clear. Otherwise, they might insist of deputy commissioners, they might insist of going ahead again. Obliged, my lord.
This is jail appeal, Lordship.
That's
Uh,
it.
Lordship, yes, Lordship, we call for LCR, Lordship.
Appeal. Earlier admitted.
Lordship. this
Anybody
call-
is appearing for appearance?
No appearance, Lordship. And we have not received the law court record also. You see.
one legal aid counsel has been appointed.
Lordship, your lordship.
So
Thank you,
am I
Pokso
cons-
matter.
so am I cons- somebody just to defend it, no?
Lordship,
Non-appeals for the applicant on the last date also.
yes, lordship.
Pokso matter,
Yeah, lordship, this conviction is only 3 years. This,
3 years,
lordship.
Notice be issued,
yes,
notice be issued,
notice be issued
yes.
for violation. You have filed this petition violation of injunction.
Yes.
For alteration of modification, my lord. Alteration and modification of the order passed by this honorable court
Against injunction,
against stay.
what state?
Against the interim order.
Against the interim or interim.
This interim order.
Yes, ex
State
parte interim.
Order.
This injunction matter.
Interim order which has passed in this, by this court, in this court on 4/9/2023.
For
4/9/2023. And in the entire petition which they have filed as a IA, that has got no merit. No merit at all. Only subject matter of it is low point. Low point is that in 2021, Arunachal Pradesh Civil Code Act was amended. As per the Arunachal Civil Code Act 2021, the appellate authority is deputy commissioner, additional district judge or a deputy commissioner, additional session judge. It was the case. Now, question is that again in 2022, the Arunachal Pradesh Civil Code Act was amended. Again, it was amended in 2023 also. Now, they tried to mingle up 2021, they tried to mingle up 2021 with 2022 and 2023. Now, my question is that when the order adjustment was passed, it was passed on 27/9/2021. When the order was passed on 27/9/2021, that is the ex parte order by the Doimuk Gambura Association. In that case, it will be governed by Arunachal Civil Code Act 2021, not applicable by 2022, not applicable by 2023. They have mistaken the law. Law is very clear. The course of action arose on 27/9/2021, and there the law which was in this case. Apart from that, they have given a stay order by Arunachal Pradesh, all Arunachal Pradesh Gaunbura and Gaunburi Welfare Association and others. Even they have shamelessly stayed the execution petition which is pending before the Deputy Commissioner. Now, see the rules, Order 21, Rule 29. If any stay is to be met upon the execution petition, in that case, only executing agency, executing officer can stay the stay order. Apart from that, this case was decided in 27/9/2021.
Yeah.
So in this case, you have already appeared, so issue notice that is not. required,
Yes,
no?
my lord. If
Yeah.
if they desires to file the reply, then if they doesn't desire to file the reply, my lord, the submission may be
Okay, one
recorded.
Respondent,
whether-
no? On behalf of Miss opposite party, you have already appeared.
Yeah.
Yes,
You are the petitioner here
yes, we are the
in
petitioner in.
In IA, he is the
in
petitioner.
revision.
No, in IA.
IA,
Yes,
Yeah.
my lord.
IA 115, no?
Yes, one
155.
155.
155,
No, 155.
155.
Yes.
Third, Mr. So as for learned counsel for the petitioner, none is done. Senior counsel has appeared for the opposite party, respondent. This is an application, under section order 39 of CPC. Bring for bracketing the ex party interim order dated 4/9/23, passed by this court in CRP number 45 in bracket AP 2023. As the learned counsel for the respondent opposite party has entered that appearance. So no formal notice be issued. Extra copies of the petition be served to him.
A matter may be fixed for final disposal next.
Final-
On
final
26th,
disposal on
26th, my lord. on
26,
This.
9,
Huh?
on 26, 9.
Oh,
26,
No, no, 26, I'm having case at 0.
Oh,
Oh, okay.
They're not agreed.
12 October.
my
26,
lord,
9.
my lord, on the case third, because we have the matter on the 3rd of October.
3rd of October.
Yes, 3rd of,
3/10.
I have no issue.
12.
Third October.
3/10.
3/10.
Okay, 3/10.
Like,
Huh?
After number? 20. 23. Hearing. Twenty-three.
Lordship, may I humbly pray that in item 23, the leading counsel Kebogo is out of station. Kalubogo is out of station. So Metron may be listed after 3 weeks. Lord.
I can hear.
In this case, leading counsel
Uh-huh.
Kalubogo is out of station. So may I humbly pray that Metron may be listed after 3 weeks.
Oh. 3 weeks.
Yes, Lord.
Concerned lawyer, Mr.
Kelole.
is out of station and prayed for adjournment for 3 weeks. And
And there is an interim order that may be continued.
extreme order is extended.
Deeply obliged.
CPC to like.